Today, I wanted to talk to you about using a power of attorney as part of your estate planning portfolio. Recently, I was asked to help a client to protect her home and pre-qualify her for long-term care benefits. She's 85 and was diagnosed with Alzheimer's, and it was not her, but was one of her children who came to our office to speak with us. The first thing I always do in cases like that is to ask whether there is a power of attorney. If there is no power of attorney, the family needs to petition a court to appoint a guardian. Your family cannot do anything on your behalf unless they either have a power of attorney, not just any, but a durable power of attorney, or a court appoints a guardian for your person and your property. In this case, there was a power of attorney, but the document was not sufficient. The power of attorney didn't allow the family to take steps they needed to take to preserve mom's home. What's interesting, though, was that the document was actually prepared by an attorney, but clearly the attorney who drafted it had no understanding of elder law or long-term care planning. This is what I need you to know. When you create a power of attorney, it's typically not for the present time, but for some unspecified time in the future when you need help. And the document should allow your family or anyone who you name as your agent in the power of attorney to do what may be required at that point of time. First, the power of attorney must be durable. Otherwise, it will terminate once you become incompetent and your family will still need to seek guardianship in court. Second, the scope of the power of attorney should be enough to enable your family to plan for your long-term care needs, especially if you haven't done any planning yourself ahead of time. But at the same time, you also want to make sure that the power of attorney cannot be abused because it's a very powerful document. So there is a balance that you can and must create with your planning. We always teach about two basic elements of estate planning. One is authority, and the other is instructions. The authority is when you give someone you trust certain powers over your person or property, and the instructions would tell that person what you want them to do or limit what they're allowed to do. And when you plan, you must have both. It's very important that what you have is a plan, not just documents. And you can come and speak with us and I'll be happy to review your existing plan and see if it's sufficient or if anything is missing. I cannot promise that we will be able to take your case, and if we can't, we will direct you to another professional, but I will give you my honest opinion about your situation and what you should do. If you need help with any of these things, call us at 201-380-2000 or visit us online at www.thelawofaging.com.
Novitsky Law Group is a full-service elder law and estate planning law firm. With 4 offices located in Paramus, Morristown, Jersey City, and Red Bank, we serve communities throughout New Jersey and New York. Call us at 201-380-2000 or visit us online at www.thelawofaging.com. Make sure that you subscribe to our newsletter to stay up to date on important developments in estate planning and elder law.